Okay, the next item of business is debate on motion 20173 in the name of Siobhan Brown on the Contract Formation and Remedies Scotland Bill at Stage 1. Members wishing to participate in the debate should press the request to speak buttons. And I call on Siobhan Brown to speak to and move the motion. Minister, around 6 minutes, please. Thank
you, Deputy Presiding Officer. The Contract Formation and Remedies Scotland Bill implements recommendations made by the Scottish Law Commission in 2018. The bill is concerned with contract law, specifically the formation of contracts and what happens in certain contexts where the terms of a contract are not met. Contract law is important to our everyday economic life and for all types of transactions involving businesses and individuals alike. Many contracts are made, carried through and become subject of disputes between parties who have no professional assistance. One of the bill's principal purposes is to produce legal rules that are clear, certain and accessible, and I, like most of the witnesses that the committee has heard from, think that has been achieved. It is important to be clear at the outset that the majority of the provisions in the bill are default. This means that parties can continue to enter into a contract on their own agreed terms and do not have to follow the provisions in the bill if it does not fit with their circumstances. This reflects the principle of party autonomy that witnesses and the committee has recognised as vitally important. The bill itself is not a complete codification of the law of contract formation. It largely restates the current law while clarifying doubts that have accumulated over the years. The main reform proposed in Part 1 is the abolition of the postal acceptance rule. Now, under this rule, a contract may be concluded without one party ever having received communication to that effect. An abolition of this rule has been a long-time SLC recommendation made a number of times over the past 50 years, and I'm pleased to bring forward a provision that will finally give effect to this recommendation. Part 2 of the bill deals with some of the remedies for breach of contract. However, this part is not a complete consolidation of the law of remedies. While the SLC consulted on this issue, it was clear from stakeholder opinion that there was no appetite for such far-reaching reform of the law. Instead, what the bill does is reform parts of the law on the steps that a party can take when the other party has breached their contractual obligations. I'd like to move on to the law of retention, which is a remedy meant to be used by parties to encourage performance of a contract without having to go to court. I wrote to the committee in October to set out my intention to bring forward amendments at Stage 2 that would reform the law. This is the end result of a period of consultation building on the considered work of the SLC and Lorna Richardson of the University of Edinburgh over the last decade or so. The law of retention is unclear, and we have an opportunity here to bring much-needed clarity. As there appears to be some doubt amongst stakeholders about whether the retention provisions will be default, I want to be clear that it is my intention that these provisions can be contracted out of. This is an important point that addresses a number of concerns raised by witnesses, of course.
Martin Whitfield.
The Minister for taking an intervention. Will the proposed amendments from the Scottish Government take account of the recent case law, which I think speaks to some of what she's already referring to?
Minister.
Yes, we'll be considering that as well. I know that the committee is supportive of these amendments, but he has asked me to look at drafting suggestions, and I'm willing to do so, and my officials will discuss matters with stakeholders in the lead up to Stage 2. The final point about the bill that I'd like to make concerns transitional provisions. A number of witnesses were strongly of the view that the provisions, if agreed to by Parliament, should apply to contracts entered into after the commencement, not to contracts that are already formed. And as I told the committee when I gave evidence, I share that view at the moment. The general practice is to provide for transitional and commencement matters in regulations. Section 25 of the bill provides for these powers. The specifics of these will be worked out as the final form of the bill becomes clearer, keeping in mind that any amendments may have a bearing on the most desirable approach here. Overall, having listened to the Stage 1 evidence, I'm pleased that there is broad consensus on the approach taken in this bill, and I welcome the committee's recommendation to agree the general principles of the bill. Deputy Presiding Officer, before I conclude, I'd like to thank the Scottish Law Commission for the considerable work that went into this reform project. I'd like to thank in particular the lead Commissioner, Professor Hector McQueen, for the time and effort that he's given to both the SLC and to the Scottish Government. I'd also like to thank Lorna Richardson, lecturer in commercial law at the University of Edinburgh, for her work with us on the general scheme for reform of the law of retention, which we consulted on earlier this year. And I'd also like to thank all of those that gave evidence to the committee and the members and clerks of the Delegated Powers and Law Reform Committee for their work scrutinising this bill. And finally, I'd like to say thank you to Lady Payton, the Chair of the Scottish Law Commission, for all her hard work over the last 7 years at the Commission. Lady Payton has personally overseen work on damages for personal injury and homicide while working with the Scottish Government to bring forward 5 SLC bills this session, including this one. Her tenure as Chair of the Commission has come to an end, and I wish her all the very best moving forward. Deputy Presiding Officer, I move that the Parliament agrees to the general principles of the Contract, Formation and Remedies Scotland Bill.
Thank you, Minister. I now call on Stuart McMillan on behalf of the Delegated Powers and Law Reform Committee. Around 5 minutes, Mr McMillan.
Thank you very much, Presiding Officer. First of all, Presiding Officer, I also want to thank Lady Payton and everyone at the Scottish Law Commission for their excellent work that they have undertaken. I do also want to thank at the outset everyone who has engaged with the committee on this bill in writing and also in oral evidence. They certainly have assisted with our scrutiny. I want to thank our excellent clerking team for their first-class support during the scrutiny of the bill. I also want to thank MSP colleagues for the way that we actually went around about the bill and the work that we undertook, and it was very much done with a collegiate approach. I'm pleased to be speaking today as the convener of the Delegated Powers and Law Reform Committee, the lead committee for this bill at its Stage 1 debate. This is the 5th Scottish Law Commission bill that the committee has acted as lead committee for in this session. And it's worth reiterating that this is a part of the committee's role and remit which members enjoy and also certainly find very much worthwhile. As set out in the Presiding Officer's determination to identify a Scottish Law Commission bill, when the committee is to be lead committee, the bill should make provision which is not likely to generate substantial controversy amongst stakeholders. That means that the bills that we look at are unlikely to grab lots of media attention, but they are nonetheless really important bills for us to look at. As the Minister touched upon, contracts are formed all the time and they are the lifeblood of the economic activity in Scotland and also internationally. Indeed, we heard that acts as simple as buying an item in a shop constitute forming a contract, which many contracts have been formed all the time by individuals without legal training or also advice. And despite this, contract law has, in a large part, been developed under common law and as such is less accessible to lay people if and when disputes arise. Now, one of the key aims of the bill is to make rules which are clear, certain and also as accessible as possible, and the committee agreed that a law like this, which sets out default rules relating to the formation of contracts and aspects of the law on remedies for breach of contract, is an appropriate way to actually achieve this. The Scottish Law Commission's work on contract law dates back almost to its inception, as outlined by Professor Hector McQueen, who acted as the lead commissioner on the project which led to this bill when he gave evidence to our committee. Anyone who reads the SLC report on review of contract law published in 2018 can be left in absolutely no doubt of the comprehensive, thorough job the Commission did, and I certainly would like to pay tribute to them for that work. And while the review was comprehensive, the aspects of contract law it recommended for inclusion in this bill were very much more limited. That certainly came up when we went through the evidence sessions. But I'd like to highlight how focused the legislation actually is, and I can certainly see much merit in the approach taken by the SLC and adopted by the Scottish Government in this case, with the bill very much focused just on the formation of contracts and certain remedies for breach of contracts. Now, this approach was widely supported by those the committee heard from, academics, as well as by practising lawyers and business representative organisations. And the rules are also largely default, meaning that by mutual agreement, parties to contracts can opt out of them. This was seen as an essential to the principle of freedom of contract and allowing sophisticated parties to continue to contract in ways that they wish to. However, the default rules will provide a clear backstop for small and medium-sized businesses should they choose to contract without opting out. This flexible approach was supported by the committee. There was also much support for the abolition of the postal acceptance rule, which the Minister touched upon. Now, certainly the idea that a contract could be accepted without being received by the offerer does not seem particularly intuitive to many without legal training. And with FSB Scotland telling us that it does not think that many of its members would actually be aware of the old rule. And as colleagues will be aware, also the question I posed to the First Minister, First Minister's questions regarding some of the issues we have with the Royal Mail, if we had a fully functioning Royal Mail, it would actually be a lot harder to argue against the status quo. So I think this particular change is really apt for the present day. Now, the committee also agreed that the general rules in the bill, which cover when notification takes effect, were reasonable, despite some suggestions that the committee heard that these could be more specific. However, the committee also heard counter-arguments that to do so and to go into more detail in the bill could prove problematic, as every eventuality cannot be legislated for, and the current rules were considered by many witnesses to be relatively future-proofed. Anyone who was in Parliament throughout the COVID period will recognise how difficult, how impossible it is to actually legislate for every single eventuality. Now, finally, Presiding Officer, the Scottish Government also plans to bring forward amendments to Stage 2, which will amend the law of retention. The committee heard a lot of support for the bill being extended to include provision on retention on condition that the provisions can be contracted out of. And we are pleased that the Scottish Government has confirmed that such flexibility will be allowed for in the new rules. And all that is left to be said, Presiding Officer, is to confirm that the committee recommends to the Parliament that general principles of the bill be agreed to. And as convener of the committee, I'd like to wish everyone a very Merry Christmas and Happy New Year. Thank you.
Thank you, Mr Macmillan. And I call Ros McCall. Around 4 minutes, Ms McCall.
Thank you, Deputy Presiding Officer. It gives me pleasure to speak in the Chamber today on the Stage 1 of the Contracts, Formation and Remedies Scotland Bill. And I want to inform the Chamber, or whoever is left in the Chamber, that I don't intend to take my full 6 minutes. And please don't take that in any way against the importance of the bill. But in my short career as a member of the Scottish Parliament, I've not had the pleasure of working on a bill that's primarily and universally supported by pretty much everybody that gave evidence. There was only one respondent, Dr Jonathan Brown from the University of Strathclyde, that was against the proposals. And whilst I understand his passion for the continued support of Scottish common law, this is an area that has been needing some clarification for some time and, as already been mentioned, is universally supported by stakeholders. I'd like to take this opportunity to thank the Scottish Law Commission, everyone that participated in the evidence sessions, and additional thanks to the clerks and staff in the committee for all their hard work. It's already been stated that the bill makes provision regarding the formation of contracts and the remedies for breach of those contracts. Many stakeholders have found the legal framework around contract law to be difficult to navigate, and the Scottish Law Commission's work leading up to the bill concluded that some parts of contract law were unclear, difficult to find and in need of modernisation, and that's what this bill is doing. It rectifies these issues. Academics are in agreement. Professor Stephen Bogle and Professor Tom Johnson from the University of Glasgow supported the proposed reforms. They said, considering the landscape of contemporary litigation in Scotland, it's increasingly evident that reform is needed, particularly due to the limited body of case law and the discernible hesitancy within the Scottish judiciary to articulate general principles beyond the specific factual matrix of an individual case. Businesses are in agreement, and the Federation of Small Business supported the bill's overall aims, with Colin Borland stating, "It's quite sensible to have the bill to provide clear backstops where they have not been agreed in other terms by parties. That makes perfect sense. As a general principle, anything that's done to codify, simplify or clarify the law and make it easier for us as lay people to understand has to be a good thing." Lawyers are in agreement. The Law Society of Scotland supported the proposed reforms when they stated, "It's clear that a new statutory regime has the potential to offer benefits to certain parties by offering users a means to form agreements without detailed understanding of case law or wider academic and institutional writings. So who are we to disagree? In layman's terms, the bill makes it easier to understand the legalities around contracts, understands the implications of them, and, if needed, the ability to contract out. So if I had to find anything that might be a small negative in regard to the bill, it would be that it's been a long time coming. The Scottish Law Commission had been looking at the issues relating to contract law since it was first established in 1965, and the bill follows recommendations by the Scottish Law Commission in 2018. 7 years in the making. Maybe, Presiding Officer, that's a little disappointing. But I'd also like to highlight the committee's finding regarding retention. At the time the Scottish Law Commission report came out, it stated that the law of retention didn't need statutory reform. But that was not accepted position when the Scottish Government consulted on the report back in 2024. Stakeholders have advised that the law of retention is now less clear than when it was when the Law Commission published its report, and that law would benefit from clarification. So I want to recognise the Minister's willingness to bring back amendments at stage 2 on this, and I welcome her collaborative approach on this issue and to the bill in general. So, in conclusion, Presiding Officer, it's a welcome bill that's finally come to pass, and I sincerely hope that stages 2 and stages 3 are equally congenial. Thank you very much.
Thank you, Ms McCall. I'm grateful to you for not using all 6 of your 4 minutes. And I now call Katie Clark. Around 4 minutes, please.
Thank you. Thank you very much, Presiding Officer. And I'm pleased to open this debate on behalf of Scottish Labour and to associate myself with the comments made by the Minister and Convener about Lady Payton. We support the general principles of this bill, while calling for the Government to work with stakeholders to consider how the bill could be approved ahead of stage 2. I was involved in the scrutiny of this bill as a member of the Delegated Powers and Legislative Reform Committee, and I thank my colleagues on that committee for the work that they have done scrutinising this bill, and all stakeholders who engaged with us in the evidence session for their involvement in the scrutiny process so far. There has been a great deal of consensus about the provisions of this bill. It aims to implement recommendations made by the Scottish Law Commission in its 2018 review of contract law and to codify the law in this area. As the Minister said, it is an attempt to codify and simplify the law. We do not accept that settled law always needs to be codified, however recognise the considerable work which has been undertaken by the Scottish Law Commission and support the contents of the bill. But we also note there is limited reform included within the bill. We hope that this bill does not lead to further litigation but clarifies the law and gives greater certainty. As the Minister says, the intention is that the law of contract should be clear. And as she also states, this bill deals with the postal acceptance rule and that there are going to be proposals in relation to the law of retention, which we welcome. The bill seeks to take forward the recommendations from the Scottish Law Commission by establishing default rules relating to the creation of contracts and aspects of the law and remedies for breach of contract, which we support. It does not intend to be a complete statutory codification of Scots common law and contract. Its provisions are intended as starting points or a default, as the Minister outlined, always retaining the option for parties to contract out of them and provide their own rules by agreement. I believe the bill's provisions may be particularly helpful in international contexts and in commercial contexts, where clarity and predictability are central to maintaining standards. It has also allowed the law to be modernised to reflect how the world has changed. I think as mentioned by the convener of the committee, how our postal services have changed, I would say, got far, far worse, not an improvement in any sense. But we have to deal with the fact that there is an enhanced role of new technology and changes to how communication takes place with less reliance on postal services. I welcome the Scottish Government's intention to introduce provisions relating to the law of intention. However, would invite them to consider the comments and drafting suggestions made to the committee thus far and to engage with stakeholders ahead of stage 2 in relation to these suggestions. And I very much hope that there will be a consensus around that. It would be helpful if the Scottish Government is able to provide any further up-to-date today on the outcome of any discussions that have been taking place already before the Stage 2 deadline for amendments, given that there will be limited time when we return after the Christmas break before the dissolution of Parliament. As I say, we welcome this bill. We welcome the approach of having a simple piece of legislation with simple language so that parties know exactly what the rules are that govern them. So we're pleased to agree to the general principles of this bill and to call on the Scottish Government to continue to seek further views on its drafting and to prepare guidance which seeks to make the law as straightforward and usable as possible.
Thank you, Ms Clark. I now call Lorna Slater. Around 4 minutes, Ms Slater.
Thank you, Presiding Officer. This bill seeks to modernise Scots contract law, clarifying how contracts are formed and what remedies apply when obligations are not met. Scots contract law is historically based on common law principles which are scattered across case law and often hard to access. The Scottish Law Commission identified in its 2018 report that parts of the law were unclear, outdated and difficult to find, creating uncertainty for businesses and individuals. The reforms in this bill follow the Scottish Law Commission's recommendations and aim to provide greater certainty and accessibility. The bill introduces statutory rules on offers, acceptance, withdrawal and lapse. It also codifies remedies for breach, including restitution and valuation of benefits where no price is agreed. These changes are intended to make the law clearer and more predictable. On remedies, while the inclusion of restitution and retention clauses is positive, some consultees expressed concern about the practical application of these provisions. For example, how courts will assess reasonable value where no price is agreed. Will this lead to more litigation rather than less? These are issues that I look forward to hearing more about as this bill moves forward. Small businesses and consumer groups have welcomed clarity, but they also caution that the bill's language must remain accessible. If the legislation becomes overly technical, it could replicate the very barriers it seeks to remove. There are also questions about how these rules will interact with existing consumer protection frameworks. One concern I have about this bill is that it allows parties to contract out of many statutory provisions. For example, a consumer pays for a service that never happens, but the contract says no refunds under any circumstances. Under this bill, this might be enforceable if the consumer agreed, even though the default law would allow recovery. Certainly.
Martin Whitfield.
Very grateful for Lorna Slater for taking the intervention on that point. I think she shares with me a concern that there is an inequality of contracting power that may be exploited by one party, particularly against individuals. And would she agree with me that this is something that needs to be looked at stage 2, even just to give us reassurance it won't happen?
Lorna Slater.
I completely agree with the member, and as I continue my remarks, he'll understand that. Well, this point about consumers being able to, or a contractor being able to contract out of statutory rights it respects commercial freedom. Some consumer advocates fear that it will weaken protections for individuals in, as Mr Whitfield says, asymmetric relationships. A corporation has clever lawyers to draft dense contracts. Certainly.
Oliver Mundell.
Thank you to the member for taking the intervention. I'm not in disagreement with the general point she's making, but would she recognise that there are other mechanisms to protect the type of individuals she talks about, for example, in terms of consumer rights, and there may be other mechanisms to address that?
Lorna Slater.
I hadn't yet concluded my remarks, so the member has not any idea of what remedy I was proposing here, so I will conclude my remarks. A corporation, as I said, has clever lawyers to draft dense contracts, and consumers often don't know what their statutory rights are, and they may not even be aware that they're contracting out of them. So my question to the Minister is, what obligations or guidance will the Scottish Government put in place to ensure that individuals entering into contracts under this legislation are not, without their full knowledge and consent, opting out of the statutory provisions that exist for their protection and well-being? Thank you, Presiding Officer.
Thank you. We now move to the open debate. I call first Bill Kidd to be followed by Oliver Mundell. Around 4 minutes, Mr Kidd.
Thank you very much, Presiding Officer. I won't need 16 minutes or 4 or anything like that sort of thing, but that's beside the point. I would like to also thank Lady Payton, as everyone else has done. I think she's absolutely brilliant in the way that she's led this and other elements of Scots law. I'd like to thank the DPLR clerking team, who have been excellent as always. And I would like to also thank the Scottish Parliamentary Legal team for all the help that they've given us. They've been absolutely fabulous. Now, Presiding Officer, this bill, though restating and reforming aspects of contract law in Scotland, will produce rules that are clear, certain and accessible. It's important economically and socially that the contract law regime in Scotland is fit for the 21st century, so we have to make changes to improve, simplify and update aspects of contract law. I am very pleased that the DPLR Committee, working with stakeholder witnesses, have managed to show a broad consensus on the general principles of the bill, because we have to make the law clearer and more accessible. The Scots law of contract has largely developed as a matter of common law, which limits the law's accessibility to those without legal training. We need to introduce a modern, clear statute which will deal with disputes between parties in a way not possible in any single court case. This bill will ensure the introduction of legislation which makes changes to improve, simplify and update aspects of common law. Delegated Powers and Law Reform Committee recommends that the general principles of the bill should be agreed to. The Law of Scotland has said that this legislation represents a modern approach and will address uncertainties on a number of specific points around contract law. If we introduce this very focused bill, we will make the law more accessible to lawyers and laypersons alike, reduce the number of disputes with consequential litigation, allow savings in court time and preparation for litigation in contributory negligence cases. This is our opportunity to ensure that contract law is fit for a modern Scottish economy. Presiding Officer, we must take this opportunity. Thank you.
Thank you, Mr Kidd. And I call Oliver Mundell again, around 4 minutes. Mr Mundell.
Thank you, Presiding Officer. I'm grateful for the clarification on time, because Martin Whitfield did tell me on the way into the chamber that he was planning to speak for 30 minutes, and it frightened me that I might not get my lunch. With that to one side, can I also associate myself with the kind words that have been said by many members in relation to Lady Payton. I think she's done an excellent job. And I think she's played a significant part in the fact we have seen these 5 bills come through in this session. And while today's debate is in the graveyard slot and there isn't a lot of controversy around it, I don't think we should allow ourselves to mistake that for saying that this isn't important. Parliament's not just here for headlines or to provide social media clips, and I think the fact we've waited almost a quarter of a century for this legislation in the devolved era to come forward does pose some questions about how we do our business. And today's debate is perhaps not the place to get into that. But I think there is room in a new Parliament for new thinking in terms of further enhancing the processes that allow bills like this to come forward, and for allowing committees more generally to bring forward legislation. But I do think there is credit where it's due to Graham Day for pushing this process forward, and also to recognise the work of the DPLR committee itself, the enthusiasm of its members, which is evident even today, just before Christmas, and to Stuart McMillan in particular for making the time to look at these bills, and for doing so in such detail and with exactly the same consideration as would be given to any other legislation. And as a past member of that committee, I know how well this has worked and how well the committee is supported by its clerks and by the Parliament's legal team. In terms of the bill itself, I think, as we've heard already, there's little question over the support for its general principles. The only substantive opposition and concerns appear to have come from those who retain a romanticised attachment to common law and the institutional writers of ages past. And when you look at the modern world and some of the legislation that makes it onto the statute books, then perhaps it's easy to see where such views come from. As other members have referenced, the world has changed, and if only we still had a reliable postal service to fall back on, then things might be different. And I get that there is attraction to maintaining traditions and distinctiveness in our legal system, but this has to be balanced and tempered by reality, both the commercial and social. Predictability and accessibility in the law do matter, and law doesn't exist in a vacuum, nor are its impacts confined exclusively within the bounds of Scotland. I think this makes a strong case for the careful and gradual codification in those areas where uncertainty has emerged. And I think it's important to recognise that that uncertainty hasn't emerged on purpose, but instead through the absence, age and specific nature of case law. This legislation in a number of key areas will make processes easier and provide, as other members have referenced, a backstop or a starting point for contract formation. That surely is a good thing. And in closing, Presiding Officer, as we've already heard, for any doubters, there will always be the opportunity for those who do not like this bill and its provisions to opt out and agree on alternatives. Those who stand to best most are the very individuals and small businesses who rely most on the law to establish fairness and balance, and I therefore look forward to the bill moving forward to stage 2 and 3. Thank you.
Thank you, Mr Mundell. We now move to closing speeches. I call on Lorna Slater to close on behalf of the Scottish Greens. Up to 4 minutes, please.
Thank you, Presiding Officer. The Greens support the principles of this bill, both modernisation and clarity. We must ensure that the bill works for individuals and small enterprises, not just large organisations with legal teams. That means clear drafting, robust guidance and monitoring of its impact in practice. This is a technical bill, but its implications are far-reaching. Contracts underpin everyday life, from employment to housing to business. We still need to approach stage 2 with consideration, listening to stakeholder concerns and ensuring that this reform delivers the clarity and fairness that it sets out to do. Thank you, Presiding Officer.
Thank you, Ms Slater. I now call on Martin Whitfield to close on behalf of Scottish Labour. Up to 4 minutes, please.
I'm very grateful, Deputy Presiding Officer, and it is a pleasure to close this, if not graveyard debate, perhaps the more terms and conditions slot that we find ourselves in, given that we are discussing contract law. This has been a serious and thoughtful attempt to modernise Scots contract law, introducing clear statutory rules on contract formation and remedies for breach that will improve certainty, accessibility and fairness, particularly for those that negotiate without the specialist legal advice that some companies and indeed corporations have. As we've already heard, the bill stems from the Scottish Law Commission's 2018 review, and like others, I would like to thank Lady Patten and also the Commission for the very, very valuable work that they do. The old 19th century concept of postal acceptance that we will see being abolished, which a number of contributors have pointed out the challenges that the current postal service provides in doing that. I would say that, and I hope I would speak for the whole chamber to say that this is not a criticism in any way of our postal workers, but perhaps the organisation that they find themselves in. The Law Commission's purpose was explicit, that they needed rules that were clear, certain as they can be made, and accessible to lawyer and layperson alike. And I think that's hugely important. In the stakeholder contributions, Colin Borland of the Federation of Small Businesses pointed out and welcomed this approach, saying, quote, "It is quite sensible to provide clear backstops. Anything that is done to codify, simplify or clarify the law and to make it easier for us as lay people to understand has to be a good thing." And I would echo that. The Law Society of Scotland noted that while it may be an overstatement to say that Scots contract law needs reform, a new statutory regime has the potential to offer benefits by providing rules that are usable without deep recourse to case law and academic sources, which we've already heard today. Can I thank the committee for their phenomenal work with regard to this and other Commission reports? And I would say gently to the convener, just because it perhaps does not attract mass interest at this stage, I think you can be certain if mistakes were made and legislation went into law that damages or has unforeseen consequences, then people would scream and shout. So the work that the committee does, I think, is incredibly powerful, even though perhaps going unnoticed is maybe one of the virtues of success that the committee has. To the contributions that we've had today, can I thank Bill Kidd if simply for getting Fabi Do into the official record again, which is well done, and to Oliver Mundell's contribution and his concern that I may be speaking for 30 minutes. I would never impinge upon the Deputy Presiding Officer or those in chair to avoid their indication of the length of time that we have to speak. So we recognise that this bill is not a complete codification. It does leave areas untouched with regard to interpretation, penalty clauses, and indeed what is commonly called the battle of forms. And I look forward to the government's signalling that at stage 2 amendments on retention that will reflect the case law will come in about, and I look forward to seeing those. So let me close with an authority germane to the purposes today. Professor Hector McQueen reflected when the SLC report was published, when implemented, this report will do much to remove current uncertainties as well as simplifying and modernising law. That is the destination. Our task here in Parliament is perhaps not to lose sight of the urgent human challenges that also require this Parliament's attention, but to move this forward as swiftly as possible. I'm grateful.
Thank you, Mr Whitfield. And I call on Ross McCall to close on behalf of the Scottish Conservatives. Up to 4 minutes, please. Thank
you, Deputy Presiding Officer, and apologies again for my error on timing. I'm going to take even less in this one. I want to highlight that it was remiss of me not to put my kind thanks to Lady Payton in my opening remarks, but as other colleagues have stated, I would like to echo that. The Conservatives will be supporting the bill at stage 1, and we will certainly be giving due consideration to the following stages, making sure that the stakeholders are still supportive as we go through that process. It has been commented on that this might be a bill that many people would not find what they call sexy, I think is the way to put it, but it is nevertheless very important and certainly something that everybody can get behind, and I think we'll see that as we move forward. I have nothing more to add other than to wish everybody a very Merry Christmas and a Happy New Year when it comes. Thank you, Presiding Officer.
Thank you, Ms McCall. And I call Minister Siobhan Brown to close on behalf of the Scottish Government. Up to 5 minutes, please.
Thank you, Deputy Presiding Officer. Thank you to everyone who has contributed to this afternoon's debate, and I'd like to repeat my thanks to the Scottish Law Commission for the work that has gone into this project and the Delegated Powers and Law Reform Committee for its work scrutinising the bill. Contract law is important to our everyday economic life, and this bill will modernise important parts of the Scots law of contract while clearing up doubts that has arisen over a few years. It is clear from today's debate that there is widespread support for the general principles of this bill. And, Presiding Officer, I'm just going to touch on a few issues that have been raised today, if I may. The electronic communication and Section 13. The bill provides a general principle on when a notification, such as an acceptance, reaches another party, and it is deliberately broad and flexible because it has to work in a wide range of circumstances and be capable of application to future technologies. And I'm pleased to see that the committee agrees with the approach taken in this section. Section 13(4) gives a non-exhaustive list of examples in which it might be considered that a notification has reached the other party, but in individual cases this must be measured against the general rule in subsection 3. An automatically generated out-of-office response may make it unreasonable to expect the addressee to be able to obtain access to it without delay, and the party sending the notification can forward it to a different email address if known, or pick up the phone or speak to someone. And it is, of course, open to parties to make alternative provision during their negotiation, and the bill does allow for this. And this reform is very important, and as members have said, in my MSP capacity, I recently visited Royal Mail in Prestwick, and I've heard firsthand all the challenges that they currently face, and our hard-working postmen all felt demoralised because all they wanted to be doing is to be delivering for the community, and postage and post was not being delivered and parcels were being prioritised. Presiding Officer, I'm also going to touch on Katie Clark and comments regarding the need for guidance as well. So contracts are used widely, and to publish and maintain guidance that accommodates the breadth of purposes to which contracts are put would be a significant undertaking. For example, our IAS have suggested that guidance be prepared for the construction sector, but any such guidance would be of limited value because the standard for formed contracts for the industry would take precedence over the default rules in the bill. So I am confident that we have a bill will make the law. Yes. Yep.
Katie Clark.
I'm grateful to the Minister, and would she be happy to write to the committee perhaps in more detail as the bill progresses, outlining the areas where it is believed that guidance might be helpful if it's sector specific?
Minister. I'm just about to get to that. So yes, so the bill will make the law more accessible and more legally certain than what we currently have, and that the guidance of the Scottish Government I do not feel is needed, which I understood was the majority view that was heard by the committee. The explanatory notes published together with the bill will provide a clear and accessible explanation of what the provisions do. Nevertheless, I have listened to the committee and I will write to stakeholders for more information, and I will consider the matter further. And of course, I will keep the committee updated. Yes.
Martin Whitfield.
I'm very grateful to Siobhan Brown taking the intervention. And on that point of the inequality of bargaining power, again, will the government reach out with regard to stakeholders to seek their views on whether there's a challenge in the fact that potentially contracts can opt out of this that may cause problems further down the line?
Minister.
Yes, and I was going to also confirm to Katie Clark when she raised it that, of course, we will be engaging with all stakeholders ahead of Stage 2. I know you want a clarification of what ongoing engagement is happening with stakeholders, and my understanding it is ongoing, but I will write specifically to yourselves just with more detail on that. Just on the consumers and protection, the members will be aware that this bill does not affect the protections laid out in reserved law or consumer protections, and this is expressly saved in section 23 of the bill. Deputy Presiding Officer, reform is needed. That is clear from the overwhelming majority of stakeholders who submitted evidence at Stage 1 and what has been said today in today's debate. This bill will modernise the law, make it more accessible and fit for purpose. There are, though, matters to consider, and I look forward to working with the committee to consider these matters. And I would ask that Parliament to support the general principles of this bill. Thank you. And Merry Christmas to everyone.
Thank you, Minister. That concludes the debate on the Contract Formation and Remedies Scotland Bill at Stage 1. There will be a very short pause before we move on to the next item of business.